Welcome to the Smart Legacy Podcast, your resource for protecting assets and securing your future. Hosted by Stockton and Kandt, join us as we cover essential estate planning and elder law topics, such as wills, trusts, and Medicaid planning. Stockton and Kandt, your trusted attorney advisors in safeguarding what matters most. You have a trust, but does it actually work? Welcome to another episode of the Smart Legacy Podcast. I'm your host, Glenn Stockton, managing partner of the estate planning and elder law firm of Stockton and Kandt, with offices in Overland Park and Gardner, Kansas. At Stockton and Kandt, we believe estate planning is serious, deliberate, and deeply human work. It's about protecting the people you love and making sure that when the time comes, your family is guided by clarity and not chaos. Each episode, we focus on helping you make informed, confident decisions about your plan, your wealth, and your legacy. Today's episode is titled, You Have a Trust, but Does It Actually Work? Will your loved ones' grief be accompanied by chaos and confusion, or will it be softened with clarity and direction? A lot of people believe that once they've signed their estate planning documents, especially a trust, that they're done. They check the box. They move on. But the truth is, having a trust and having a plan that actually works are two very different things. Today, we're going to talk about what it really means to have a plan that works through proper trust funding, beneficiary designations, and overall wealth alignment. So let's get started. You have a trust, but does it actually work? I think, people often treat estate planning as if it's about the documents. They treat it as a transaction. It's all about the paperwork, right? You go to the attorney to get the will drafted, the trust drafted, and it kind of ends there for most people. And they think by just having the documents done, I think they often feel like it's complete. Or they get busy and they forget that they had some work to do. But a plan only works if it's properly funded and properly aligned with your assets. So let's talk about what does it mean having a plan that actually works, right? It's not about the documents. The documents are just the starting point. Plans fail due to a lack of implementation. We see plans fail every day, not because they were poorly drafted, but because they were never fully implemented. The trust itself may have been a beautifully drafted trust, but if the assets didn't get aligned with the trust, it doesn't work. And as a result, families, the loved ones end up in probate, there's confusion, there's family quarrels. It was all because there was a lack of alignment. So we like to tell people, think of estate planning as a four-legged stool. Leg one of the stool is about the documents, right? The trust, the wills, the powers of attorneys, those documents are important. They're what keeps us out of court. They set forth who gets what and when. They're very important. But the documents are just one leg of a four-legged stool. We want to make sure that those documents also address long-term care. If you ever need to go into assisted living, nursing care, that we have a plan. We want to make sure we minimize taxes. But leg four of the stool, those are the other two legs. So we have the documents themselves, foundational documents, a plan for long-term care, how to minimize taxes. But leg four of our stool is making sure that we have alignment with our assets and our estate plan. So we tell people, think of a trust as being like a safe. It's a legal safe. The person or people that create the trust, legally, we refer to them by all kinds of names, grantors, trustors, settlors, but they're the trust makers, right? They create this safe that is the trust. But we have to get assets into the safe, right? The safe only protects those things that are in that. And so if all we did is sign a trust into existence, we have an empty safe. So funding of trust is actually putting the assets into the safe. So examples might be, getting your home or other real estate in the home into the safe, right? So you own your home. How do we get it into the trust? Well, we're going to have to file a new deed, and that deed's got to be recorded with the county that transfers ownership from the individual owner to their trust. We're going to retitle accounts. You go to the bank, and instead of owning your checking account in your individual name, or for a married couple, instead of owning it as joint individual owners, they have it titled to their joint trust. We had a business, an LLC, or a corporation. With the LLC, we're going to assign the interest in the LLC over to the trust. Or with corporations, we're going to reissue the stock into the name of the trust. We just have to get the things into the safe, because if we have an empty safe, it's not going to help us. And trusts fail when they're not funded, right? They don't provide any protection unless the assets are there. And it just gets missed so many times. We see this frequently. That's why in our firm, we like to do what we call the annual review meeting. We want to come in each year, and each year we go through each of the 4 legs of the stool. And I'd recommend to you that you do the same thing. Each year, review those foundational documents. Are they doing what you want them to do? Here's who you named to make financial decisions when you can't make those decisions on your own anymore. Here's who you named to make healthcare decisions. Here's who you named as your beneficiaries. Here's who you've named as your trustee. Are those still the decisions that work for you today? Is it still the way you want it? And what we find is most years it's like, that stuff it can change, and it does change for most people over a long period of time. But year to year, most of the time, we don't see a lot of change there. And then in those annual review meetings, we're also going to evaluate, is our plan for long-term care, whether it's nursing care in a skilled nursing home, is it assisted living, is it home health care, wherever you receive that care. If you need to go into long-term care, is the plan that we have in place is still appropriate? Do we need to make any adjustments? Has anything changed with your health? And again, most years, nope, we're good there. We go to leg 3. We look at taxes every single year. We're going to look at your taxes. How do we minimize taxes? And then each year, you look at your assets and you make sure everything's titled. And guys, the taxes each year, making sure we have a plan for taxes and making sure that our wealth is aligned with our plan is where we see the most work needed to be done on an annual basis. But typically, people are not doing that because they treat it all as being about the documents. They went to the attorney, they had the will drawn up, the trust drawn up, and they stuck it in a lockbox or their safe or some place of safekeeping, and they haven't looked at this thing for 10, 15 years, sometimes longer than that. And the client assumes it was handled. Oh, I have a trust. It was handled. But the trust never got funded. The assets didn't get moved in. And if the assets are outside of the trust isn't protecting them. They're not helping them. If there's beneficiary designations on those assets, right? They were owned in your individual's name and you have a beneficiary designation that's different than what the trust plan was, those beneficiary designations are going to control. So each year we want to make sure that we're looking is everything titled properly. Are things that are supposed to be in the trust, are they actually owned in the trust? And then we're also going to look at beneficiary designations. Are they properly aligned? So let's talk about what goes into the trust, right? So think of the trust as a safe. We've got a safe, and now we're going to put our assets into the safe. And so you've created this trust during your lifetime. I want the bulk of your property to be owned by the trust. A trust provides powerful, protections at death to make sure that your assets go to who you want, when you want, the way you want, keeping the courts out of this, making this as easy as possible for those you leave behind. But trusts also provide powerful disability and lifetime protections. But it only applies those protections or provides those protections if the assets are in the trust. So we want most of your assets to be owned by the trust. Your home, your bank accounts, your investment accounts, most of your assets are going to go in there. And we'll talk here in a minute about how we do that. But there's a couple assets that typically are not going to be in the trust, at least not in the beginning. The first are your retirement accounts, IRAs, 401ks, 403bs, 457 plans, 401as, all these different retirement plans. IRA stands for individual retirement account, right? Individual being the operative word. They have to be owned by you in your individual capacity. They cannot be owned by your trust during your lifetime, your plan. The trust can certainly be a beneficiary of the plan, but the person who created that plan cannot put it into the trust during their lifetime. They must own it in their individual capacity. And that's true for IRAs, but it's also true for the 401ks and 403bs and other retirements out there. So we don't want to have those accounts that can't go in the trust. So typically there, you're going to keep them in your individual name. If you have a spouse, the typical rule for the retirement accounts, if you're married and you want those to go to your spouse, is the spouse would be the primary beneficiary, because spousal beneficiaries get certain rights that a non-spouse doesn't get, and the trust is not your spouse. So we name the spouse as the primary beneficiary, but the trust becomes the contingent beneficiary. When it passes on to your kids or grandkids, whoever you've named as that backup beneficiary to your spouse, well, they already weren't your spouse. And when we put them through the trust, they get the protections of the trust. So retirement accounts don't go into the trust during your lifetime. I'm also not a big fan of putting your daily driving vehicles into the trust, into the safe. You could, but my general recommendation on vehicles, especially those daily drivers, is to have those titled in your individual name and name the trust as the transfer on death beneficiary, right? And you do that on the title of the vehicle. The IRAs, we just list the trust as the contingent beneficiary on those accounts. Other accounts that we would not put into a trust would be during your lifetime would be an HSA, for example, health savings accounts. I'm also want to be very careful we put timeshares in. But other than those few things, your retirement accounts and HSAs, your vehicles and timeshares, pretty much everything else we want to be owned by the trust. Now the trust provides protections during your lifetime, but it also then provides the protections at death. If the assets are owned by the trust, right, they're in the safe. They were in the safe when you were alive and well. They were in the safe if you became incapacitated. They were owned by the safe when you died. They're not going to go through probate. The trust just says, hey, while I'm alive, this would be a typical way for a trust to work. While I'm alive, these assets are to be used for my benefit. So even if I can't make decisions for myself, I've appointed somebody else to manage those assets for my benefit, or if I'm married, for my and my spouse's benefit. Typically, we say, hey, the kids they don't get a run to Vegas on your money yet. You're still alive. They may be the ones who are managing it. They might be your successor trustees, the people that had the backup key. But they're managing it for your benefit. You're still alive. But then when you die, the assets are still owned by the trust. They're not going to go through probate. And if you'll remember, as we've discussed probate in prior episodes, the process of probate, or really the function of probate, is to take assets that are titled in the name of someone who's deceased and retitle them to the name of somebody who's alive. And that's really how trusts avoid probate. It was owned by the trust while you're alive and well. It was owned by the trust when you became incapacitated. It's still owned by the trust when you die. We don't need the courts to come in to change ownership. It's already in the trust. The trust just says, hey, when I die, this is who I want the assets to go to. And we can leave it to them in continuing trust. We can leave it to them outright free of trust. Each person gets to make their own decisions on that. So we need to make sure the assets are in the safe. They're in the trust. The trust is where our protections for ourselves are at, our lifetime protections. It's where the protection for our spouse is at. It's where the protections for the kids is. It's where our distribution plan is at. So we got to get the assets into the trust. All right. So getting them in, making sure that you look at it on a somewhat regular basis, at least every few years. We like the annual review meeting process. Just once a year, let's put our eyes on this. And through our firm, what we like to do is I have my clients give me updated statements. Get me bank statements. Get me investment statements. Give me the statements on the IRAs. When I look at a statement, I know from that statement how it is titled. I also know how it's taxed. Right. And so each year, by getting updated statements, we can make sure that the assets are titled the way they're supposed to, where they're supposed to be, and avoid there being a mismatch between the plan and the actual titling. All right. So how do we get the assets in? Well, let's start with the home. I already mentioned that one, right? So home, farmland, the lake house, rental properties, if you own them in your individual name, they're not part of an LLC. Any, real estate that we want to put into the trust, we have to do it by way of deed, right? It's the only way that you can pass property. Typically, we're going to use what's called a quitclaim deed. We're just transferring whatever interest I own in my home, I'm now transferring it to my trust. And we do that by way of a deed, and then that deed has to be recorded with the county register of deeds office in whatever county that property is located. And if we think of the trust as being like a safe, it can own property in multiple counties. It can own property in multiple states. It can hold all kinds of different property, real estate property. It can own mineral rights, oil wells, all those types of things. But we're going to pass those by way of a deed. We have a deeded interest. We're going to deed it into the name of the trust. What about the bank accounts, checking, savings, money market accounts? Well, there we're going to name the trust as the owner on those accounts. So we're going to go to the bank and we're going to ask the bank to retitle those accounts into the name of the trust. And if we're talking about a grantor trust, right? And specifically, let's talk today about the revocable living trust. Let's talk about the revocable trust, most common type of trust we have. We can transfer those bank accounts. You go to the bank and title them in the name of the trust. And usually you're going to provide your bank with what's called a certificate of trust, or it's also known as an affidavit of trust. It's just telling the bank or financial institution the information they need to know about the trust. A revocable trust, living trust, a grantor trust, its tax ID number is the Social Security number of the grantors typically. Could have a separate one, but most often we're going to use the Social Security numbers. It's a disregarded entity when it comes to taxes. The IRS doesn't care anything about your revocable living trust, right? So when we go to the bank and we're transferring those accounts into the name of the trust, they just simply move them in. We don't have to open up new accounts. We don't have to get new debit cards or new checks. We don't have to redo our auto pays. All we're doing is titling the name of those accounts. We're titling those accounts into the name of the trust. We do that with checking accounts, savings accounts, money markets. We can do it with CDs, right? All those bank accounts that we have, we move them into the trust. Our investment accounts, brokerage accounts, stocks, bonds, that type of thing. We want those accounts titled into the name of the trust. Now, if it's individual shares of stock, we're going to have those reissued into the name of the stock because they're issued, if they're not held in a brokerage account, you hold them in your individual name, you're going to have to reissue that stock or have the company reissue the stock into the name of your trust. Those accounts can go in. Annuities. Now, annuities, I will say this, a little caveat. Typically, we want to have the annuity owned by the trust. I want the trust to be the owner because remember, that's where our lifetime protections are at. If you create a trust and you've got the key to the safe, right, you're the trustee, but if you are no longer able to manage your affairs, you had a stroke, developed Alzheimer's, went bungee jumping and bumped your head, whatever the issue is, you can no longer manage your affairs. With the trust, you've named who has the backup key, who that successor trustee is. And if the assets are in the trust, they get to manage them, from an owner aspect. They're the new CEO of this trust, and they can manage the assets. So I want to get the assets in. So typically, I want that annuity titled into the name of the trust. But we do have this caveat that we need to make sure that we're not going to lose anything by doing so. So because sometimes these annuities have, bonuses or something tied to them. And if we change who the owner of the policy is, it can interfere with that. So we do need to exercise a little bit of caution. And if it would interfere with that at all, then on those accounts, like the IRAs, we're just going to name the trust as the beneficiary. But for non-qualified annuities, to the extent we can without causing issues, we want those titled into the name of the trust. And we're going to do that with most assets we have. If we have an LLC, we're going to assign the ownership interest of the LLC to the trust in many cases. If we have a small corporation, we're going to reissue the stock into the name of the corporation, like a small, family business or something. We just want to get everything into the safe, into the trust. That's what we call trust funding. It's not overly difficult, right? But there is a little bit of heavy lifting you have to do once the trust is signed into existence. We can't fund it before the trust exists, but once we create the trust, once we sign it into existence, then we have to go about doing the work to get the accounts retitled into it. So you take the trust certification to your bank, and each account, you retitle it into the name of the trust. You take the trust certification to your financial advisor, and you have them retitle the names of the non-qualified, the non-retirement accounts into the name of the trust. With the retirement accounts, remember, then we're going to name spouse as primary beneficiary, and then we're going to name the trust typically as the contingent beneficiary. So we just need to get the assets into the trust. And when we do that, we have alignment, right? The trust now holds it. It's the owner of the trust. If you become incapacitated, your successor trustee steps in and they are able to manage those assets. And the protections of the trust are provided. So we got to get the assets in. It's a common problem we see that people do not get about to funding the trust, or maybe they did it at the outset, but then over time, and they sold a home, they bought a new home, they failed to get it into the trust, or they closed up bank accounts, opened new accounts, they didn't get them in the name of the trust. And we see this all the time, where then people die. They thought they had things covered, but they didn't. And then their loved ones find that now they have to go through probate because we didn't make sure that things stayed in the trust where they belonged. So trust can provide powerful protections, but we got to make sure we get the assets into it. Let's talk real quick about wills. What do we have with a will, right? Let's say we have somebody who didn't do a trust. I'm a big believer in trusts. I'm just not someone who believes everybody necessarily needs a trust, but trusts are powerful estate planning, vehicles. But for someone who has a will, right, we don't have the trust. Well, then we're going to need to use beneficiary designations, right? This is how we're going to avoid probate. And we need to make sure that they are in alignment with our plan, right? Because if we don't have a beneficiary designation on, yes, it's going to pass in accordance with the will, but it's going to have to go through probate. So often we're just going to want to make sure that as part of our will-based plan, we're aligning the will with beneficiary designations, really trying to, where the will becomes more of a sweater in the suitcase, we're trying to avoid probate by using beneficiary designations. So what I would encourage you to do is look at this stuff. If you have a trust, is it funded? Have you reviewed it recently? Are you making sure that everything's titled properly? Are your beneficiary designations aligned with what your plan, is? Is it all in alignment? Has anything changed? Have you changed banks, bank accounts, moved to a new home, started with a new financial advisor? You want to make sure that you're looking at this stuff on a regular basis. We believe just getting in this cadence of once a year. We like the annual review. In our firm, for those of you who are clients, you know this about us already, we like to meet with our clients on an annual basis for the annual review. We don't charge for those meetings. I encourage my clients, take us up on this. Each year, we're going to go through each of the 4 legs. We're going to review the documents. This is who you named to make financial decisions. This is who you named to make healthcare decisions. This is who you've named as your beneficiaries. Still the way you want it. Is our plan for long-term care great? We're going to look at taxes. Is there any tax planning we need to do? And then we're going to look at the wealth alignment. We're going to get updated statements just to make sure that the I's are dotted and the T's are crossed. So if you haven't done that, if you're a client of ours, call the office, get set up for an annual review meeting to come in where we can help you look at this. If you're not a client of ours, well, at least look at this stuff yourself. Make sure that things are titled properly. Because I talk about the 4 legs of the stool. The seat of the stool is really about being good stewards of our plan. Remember, the goal for most people when they do estate planning, They're trying to create clarity. They want this to be easy for their loved ones. They don't want to be a burden. But if we don't pay attention to stuff, if we don't make sure that this stuff stays in alignment, we're likely to leave an unfunded plan or maybe only a partially funded plan. And our loved ones are going to find that they are in probate court. And instead of clarity, we've created chaos and confusion. So hope this was helpful. Thank you for joining me for another episode of the Smart Legacy Podcast. If you found this helpful, I encourage you to share it with someone you care about, because these are the kinds of conversations that can make a real difference for families. And if you're getting value from the podcast, I'd invite you to like and subscribe so you don't miss future episodes. If you'd like to explore more and look back at past episodes, you'll find the Smart Legacy Podcast on Spotify, YouTube, and Apple Podcasts, as well as on our website at stocktonlaw.com. And if you're listening today and wondering whether your own plan is properly structured, funded, and aligned, that's exactly the work we do. At Stockton Kandt, it's our privilege to serve as a trusted advisor to families through the seasons of life, helping ensure that when the time comes, your loved ones are supported with clarity and not left with confusion. Until next time, take care of yourself and the people you love. Thank you.
The information provided in this podcast is for general informational purposes only and does not constitute legal advice. Listening to this podcast does not create an attorney-client relationship. Laws vary by state, and this podcast focuses on estate planning and elder law in Kansas and Missouri. If you are located in Kansas or Missouri and require legal advice, please contact our office. Otherwise, consult a qualified attorney licensed in your jurisdiction.